I'm sorry. Oop, I didn't know I was mic'd. There's a light in my eye, so just if I'm squinting or doing this, that's why. So good evening. I appreciate you all taking time to come this evening and giving up your dinner, or maybe having a later dinner or an earlier dinner. I appreciate that. I am with the Florida Department of Education, the Bureau of Exceptional Student Education, and I'm a program specialist. Today we're going to talk about discipline as it relates to Section 300.530 of Title 34 Code of Federal Regulations, as well as our state rule, Rule 6A-6.03312 Florida of the Florida Administrative Code. Excuse me. So in the Federal Administrative Code for the state, it says, it defines manifestation determination as the relationship between the student's behavior or the student's current behavior and the student's disability. It also states that a decision must be made within 10 school days of any decision to change the placement of a student with a disability because of violation in the student code of conduct. So, according to the federal regulation, when a district proposes the removal of a student that would exceed 10 school days due to a violation of the code of conduct, it is the district and the parent, or the LEA, the district, and the parent, and the relevant members of the IEP team that is determined by the district, the LEA person, and the parent, who are on to determine who's on that manifestation determination team. The manifestation determination team gets together to answer two questions. The first one, was the conduct in question caused by, or did it have a direct and substantial relationship to the student's disability, or was the conduct in question a direct result of the district's failure to implement the IEP? This section says that the manifestation determination team has to come together, make a decision, and if warranted, take immediate action to rectify the situation. So if either question is answered yes on the previous slides, if they answered yes, that it was directly related to the student's disability or it was a failure to implement the IEP, two things have to happen. The first thing is the district must conduct a functional behavioral assessment and develop a behavioral intervention plan. Or if the student already has a behavior intervention plan, the team should review it to make sure it addresses the student's current behavior. The second thing the district has to do is return the student to the original placement. So they can't keep them where they move them to. They have to return them unless the parent and the district agree as part of the behavior intervention plan to change the student's placement location to receive services. Or it's a 45-day removal, which we'll talk about. So this part says if the answer is no to the questions, that it's not a manifestation of the student's disability, then the student with a disability can be disciplined in the same manner of students without disabilities. So if they skip school and they are found it's not a manifestation of the student's disability, whatever the ramifications are for the students without disabilities could apply for the student with disabilities. I'm just going to get this out of the way. So for a parental dispute, you have the right to dispute the decision that's made. And I just want to, sorry. The district does have to inform the parent of their right to challenge the decision. Those are in your procedural safeguards, which I'm sure we're all familiar with. We could probably plaster the walls with them. So it's an expedited hearing request. And with an expedited hearing request, it's different than a regular hearing request. A regular hearing request can take 60 days, no longer than 60 days. With an expedited due process hearing request, it's 20 days from start to finish. And within that timeline, a resolution meeting has to occur within 7 days. And if no resolution is had, then the process continues. And an administrative law administrative law judge will make a decision. If the district has not provided you with prior written notice, they have to do that at that time. The student has to remain where they are, so it's a stay put, and this is only for expedited hearing requests. And then whatever the administrative law judge determines is what it is. The state cannot supersede what a judge rules. So what can an administrative law judge do? What authority do they have? They can return the student to the original placement, or they can order a change of placement. It could be what the district recommended. It could be a more restrictive placement. So only an administrative law judge can change a student's placement. The state, if you file a complaint or something to that nature, we only look at the process. We cannot determine a student's placement. Only an administrative law judge can do that, or the IEP team. So let's talk about removals. So this regulation and rule permits students with disabilities who violate a code of student conduct to be removed from their current educational placement for not more than 10 consecutive days at a time, and additional removals would be considered a change of placement, which we'll get to that in a moment. Meaning, if the student has a change of placement, they're not receiving their services or participating in the general education curriculum. So if a student is serving an in-school or out-of-school suspension, that student should be provided their services, as well as being able to participate in the general educational classroom. If they do have an indoor school suspension or an out-of-school suspension, and there's no services being provided, and we're over the 10-day mark, then a manifestation determination meeting would have to take place within 10 days. So when we talk about change of placement, we're talking about, it's a change in the Code of Federal Regulations. It's 300.356, but it is the same rule, Florida Administrative Code 6.03312. So Part A of this section states that the purpose of a removal, For the purposes of removal from the student's current placement changes, if the removal is more than 10 consecutive school days, so let's say a student has been placed in school suspension or out of school suspension for more than 10 days, and they are not receiving their services and they are not participating in the general education curriculum, then a manifestation determination team would have to meet. In addition, the child's been subjected to a series of removals that constitute a pattern of removals. And that is if the series total more than 10 days. So 3 days in school suspension and maybe 6 days out of school suspension. And they're not receiving their services, it is considered a change of placement. Because the child's behavior is substantially similar to the child's behavior in previous incidents that resulted in the series of removals. So if the student is continually fighting and we say, no, it's not a manifestation, no, it's not a manifestation, but it's happened 7 times within 3 months, it very well could be. The student may not have been suspended for more than 10 days, but it could be a pattern of behavior to be looked at. The last one, they also look at additional factors such as the length of each removal, the total amount of time the child has been removed, and the proximity of the removals to one another. So in that previous example with the student being suspended within 3 months of each other, those are pretty closely related to each other, so it could be a pattern of removals. But if, let's say, a fight or the student was verbally aggressive to a staff member in September and then again in April, that's a long time. So that may not, or it could be a manifestation of, it could constitute a pattern. And it says it's a case-by-case basis. Every situation is unique. Every child it's different. And so that's why they say it's a case-by-case basis. We look at the IEP, we look at the discipline records, we look at whatever is needed to make a determination on whether it is a manifestation of the student's disability. And again, this determination is subject to review through due process and judicial hearings. I would like to quote, because they say it best. So in the analysis of comments and changes section of volume 71 of the Federal Register, August 14th, 2006, on page 46,729, it includes the following statement regarding this section. Whether the behavior and the incidents that resulted in the series of removals is substantially similar should be made on a case-by-case basis and include consideration of any relevant information regarding the child's behaviors, including where appropriate any information on the child's IEP. It goes on to say, however, we believe when a child's behaviors taken cumulatively are objectively reviewed for determining whether the series of behaviors constitute a change in placement, the public agency will be able to make a reasonable determination as to whether a change in placement has occurred. So if you've sat in our other presentations, we always refer to a district's, we call it an SPNP. It's the district's exceptional student education policies and procedures. And when you go to that link, it will take you to the district's policy, well, their policies on everything related to special education. And if you go to Part 2, Section D, it is the district's policies on discipline, which includes manifestation determination, administrative hearings and things of that nature. Every district has their own way of doing things, so it's important to look and make sure, I encourage you to look at their policies and procedures. And they have to update their policies at least every 3 years, unless the law changes, then we have to update it, and they have to update their SPNP and to be compliant. Okay, now we're going to move to providing a free a free appropriate public education for students who are suspended, expelled, or placed in an interim alternative educational placement. So if a student with a disability is removed from their current placement, the student must be provided their educational services so that the student can participate in the general curriculum, continues to receive IEP services, and continue to participate with non-disabled peers in relation to their current placement. Students with disabilities removed for disciplinary reasons must continue to receive services and receive as appropriate a functional behavioral assessment and a behavior intervention services that address the student's behavior. So again, this is saying, again, that services must be provided, including if the student is moved to an interim alternative educational setting. I'm going to quote this again in the analysis of comments and changes, section volume 71 of the Federal Register. They say that we caution that we do not interpret participate to mean that a school or district must replicate every aspect of the services that a child would receive if in his or her normal classroom. For example, it would not generally be feasible for a child removed for disciplinary reasons to receive every aspect of the services that a child would receive if in his or her chemistry or auto mechanics classroom, as these classes generally are taught using a hands-on component or specialized equipment or facilities. So for certain violations of code of conduct, a district may remove a student for not more than 45 days. And so regardless of whether it was a manifestation of the student's disability or not, if it is, the school may or may not. It doesn't say they have to. So if a student carries a weapon to or possesses a weapon at school, on school premises, or to or at a school function, knowingly possesses or uses illegal drugs, or sells or solicits the sale of a controlled substance while at school, on school premises, or at a school function, inflicts serious bodily injury upon another person while on school premises or at a school function. So for students that are removed for a drug or weapon offense or for inflicting serious bodily injury or for violating the code of conduct that would lead to the removal for more than 10 days, the district must, as appropriate, again, provide the FBA and behavior interventions designed to address the behavior so that it does not reoccur. Again, this must be provided regardless of the manifestation determination outcome. Under Part H, notification states that when a decision is made that constitutes a change of placement, the district must notify the parents of that decision and provide the procedural safeguards. You can also see the definitions for controlled substance, illegal drug, serious bodily injury, and weapon. The resources that I've provided the first one is the Bureau's website, the Bureau of Exceptional Student Education. We do have an emotional behavioral disability webpage that has resources and the rules and regulations. Also, the Multi-Agency Network for Students with Emotional and Behavioral Disabilities, SEDNet, is federally funded and is free to parents, and they work with students and families and schools and the community and try and bridge that gap between school and community, and they can also provide community resources in your area. The next one is the Center for Parent Information and Resources, the Parent Center Hub. We like that website. It's federally funded, and they put it in family-friendly terms that I can understand. And also the links to the federal regulations and the Florida Administrative Code that I've reviewed. A little bit about SEDNet. When you go to their website, this is part of what will pop up. And if you're looking for assistance, this is a good place to start. If you need, I know some families deal a lot with mental health issues. They're a great resource. And if you click on local regions, I've circled it, and click on your region, your district, it will tell you who the project manager is for you to get in touch with, who can steer you in the right direction and provide resources needed for your family or student. And so I ended a little early so that we all can go eat dinner because it's late and we're hungry and we're tired. So I thank you very much.